May I have your attention, please? Good morning again.
Good morning to all. Registrar, you may open the proceedings.
Thank you, Madam President. Hearing of the 14th Annual Caribbean Court of Justice International Law Moot. In the matter of Moot 003 of 2024 between TT Distributors and the Republic of Trinbago. The members of this morning's panel are Madam Justice Rajnath Lee, President and Presiding Judge, Mr. Justice Barrow, and Mr. Justice Jamida. May we have the appearances, please?
Good morning, Your Honors. Counsel for the claimants are myself, Senior Counsel, Andis Thomas. Co-counsel,
Who is myself?
Andis Thomas.
Okay.
Yes, Your Honor. We have co-counsel, Ms. Dividi Ramdas, and instructing attorney, Ms. Kerry-Ann Manichan.
Okay.
Thank you very much. We are aware today that your opponent is not here.
Yes, Your Honor.
So please, if you're ready, Ms. Thomas, please come to the podium.
Ms. Thomas, by way of preparation, because there is not an opponent to actively engage you, if you find that we engage you a bit more than you expected, it is quite proper that we should do so, as it were, to tease out of you those things which an opponent would present and to which you would have to reply. So do not be taken aback if we seem unduly combative or penetrating in our inquiries. Yeah?
Thank you for preparing me, Your Honor.
Good.
Once again, good morning, Your Honors. Andis Thomas, counsel for the claimant. And with your leave, Your Honors, I would like to begin.
Yes, please begin.
Well,
Your Honor-
before you begin, why are you here before us this morning?
Your Honors, counsel for the claimants wish to be heard on two issues, two general issues.
What do you want from the court?
We are seeking from the court recourse in the form of certain relief to be discussed by my co-counsel for breaches of several articles of the RTC by the defendant, the Republic of Trinbago.
Is that why you're here?
This is one of the reasons that we are here, Your Honor.
So are you here maybe because you want special leave of this court?
Yes, Your Honor. We also
okay.
seek, yes, we seek
What is
special
the article that you come under to seek special leave?
Your Honors, we come under the articles of 211 under the RTC, first of all, which gives this court the inherent jurisdiction to hear contentious matters revolving around the interpretation and application of the RTC. Secondly, Your Honors, our claimant is a private entity, and therefore we would like to establish locus standi of TT distributors under Article 222. 5 conditions have been satisfied, Your Honors, and counsel for the claimants believe that as they have been satisfied, the
Is
private...
that in your written submission?
Your Honors, no, it is
No.
not in our written submission.
I see. So when you say to us orally this morning, you said 5? 5 conditions? Is that what you said?
There are 4 conditions, but we refer to the first line as one of the points
All
that we
right.
would consider
Okay,
under
fair enough.
222.
So if you
Yes.
say to me or to us, the 5 conditions have been satisfied,
Yes, Your Honor.
that doesn't help me because you've not written anything about it to say that Article 22, we are coming under Article 22,
222.
222, sorry, thank you. And these are the conditions and they have been satisfied because whatever. And you were going to start your submissions, were you not, without doing that?
Your Honor, I'm guided by your...
That should be the first thing, isn't that right?
Yes, it is, Your Honor.
Right.
I will let Your Honors know that counsel for the claimants did recognize this, and we were going to establish the local
right.
standi of the private
Then,
entity.
then I wouldn't keep you back.
Yeah.
Go ahead.
So you're going to start with locus standi.
That is
Please go
correct.
ahead under 222. Yes.
Yes,
Thank
so I
you.
will speak to 222. First of all, Your Honors, the claimant, TT Distributors, are a juridical person established under the laws or incorporated under the laws of a member state, that is Trinbago. The first criteria under 222 has been met because as a juridical person established under the laws of Trinbago, the claimant's TT distributors are entitled to certain benefits under the RTC, and in particular, the benefits under Articles 32 and 82. Your Honors, these benefits have been prejudiced of their right to enjoy these benefits. Your Honors, also, as was done in the case of Trinidad Cement Limited, Guyana in 2009, this court allowed a private entity to bring a matter against the very state under which it was incorporated. And like this case, our client, TT Distributors, are bringing a case against the very state under which they are incorporated. And this is because it cannot be reasonably expected that the state of Trinbago would bring an action against their own selves. And this is why the private entity is bringing the matter before the court. Finally, Your Honors, it is in the interest of justice that this matter be heard. And this is again based on the fact that the claimants have been prejudiced, Your Honors, of their rights, their benefits, which they should have enjoyed under Articles 32 and 82. I hope we have satisfied Your Honors.
You certainly
sufficiently.
satisfied me that you prepared it, even if you didn't write it. Thank you.
Guided, Your Honor. Very much guided.
There's one other thing that I wanted to raise with you before you embark, because I imagine now you will embark on your Article 32 point.
That is correct.
Before,
Well, Your Honors,
sorry.
sorry to interrupt you. We will begin with Article 82, and we will use Article 82 as the most pivotal breach, which resulted in the other breaches. So I'll begin with 82, just to offer that guidance
Okay.
to the court.
Okay,
Yes.
because what we observed is that you weren't very kind to us. You did not tell us what issues you would be looking at. So that we know that you have a very nice opening statement. Your first paragraph tells us a lot, but you didn't identify what issues. And I don't know if you know, but judges are very hardworking and sometimes overworked, especially if you go to a first instance court or an appellate court. And I wanted to say that as much assistance as you could give the court would be something that the court would appreciate. So for example, when we look at what you say here, you say Article 32, but you tell us nothing more. So, another counsel might say whether Trinbago breached Article 32 or whether TT Distributors is entitled to special leave for an alleged breach of Article 32. But you just gave us the articles and you ran with it. So I think that is something on the next occasion that council might want to look at.
We are very much guided by this, Your Honor. And although we were restrained with words, we are guided that this should probably take precedence over some of the other things that we have discussed. Your Honors, the issues is part of my opening, however, and I hope this compensates for the lack of that in the written submission. So the first two issues which we wish to be heard on were the two that I will be speaking to right now, Your Honors. May I proceed?
Yes, please.
Okay.
Thank you very much for that.
Yes. First issue, Your Honors, on which I will be speaking is whether the non-impositioning of the 40% CET, common external tariff, on the third state goods from Indonesia into the Republic of Trinbago resulted in a breach of Articles 32, 82, 83, and 84. Following my discussion on this, you will hear from my co-counsel on the second issue, Your Honors, which is whether this action, along with other actions and inactions of the state of Trinbago, including a widely misleading marketing campaign, led to the breach of Article 91. Your Honors, just to guide you, co-counsel will also discuss the relief being sought by the claimants. Your Honors, with your leave, I would like to now begin with my first substantive point of argument.
Yes, please.
As I mentioned, we'll begin with Article 82 as it is the most pivotal breach counsel believes. Your Honors, Article 82 is very short and simple in nature, and it's not ambiguous and should be interpreted in the most literal way. Article 82 simply encourages or employs, not encourages, but employs each member state to maintain the common external tariff to be imposed on goods which are not of community origin. And not only to maintain them, Your Honors, but to maintain them in accordance with quoted regulations. Your Honors, in the matter before us today, this was not done by the defendants. Your Honors, soap noodles imported into Trinbago should have attracted a 40% tariff based on quoted regulations. Your Honors, there was a reclassification done by the Controller of Customs, and a 5% tariff was instead imposed on these soap noodles.
Just stick up in there, sorry. is it that, what did you say? There was a reclassification
That is
done?
correct, Your Honors.
How do you see that? How did you see that happening? How did that happen?
Your Honors, it is not a disputed fact that soap noodles arrived into Trinbago and the comptroller reclassified the goods under the
Why do you use the word reclassified?
We use, oh, now I understand, Your Honors, and let me just answer this question again. Your Honors, we use the word reclassified because the soap noodles there's no evidence from the defense to prove that the product imported, which they referred to, Your Honors, specifically referred to in an application to the Secretary General as soap noodles. So they themselves agreed that it was soap noodles, Your Honors. This is not in dispute by the
Thomas,
defense.
I
Yes,
think
Your
the
Honors.
slide focus, it's a nuanced point, is whether there was a reclassification or a classification that you may want to say is a misclassification. Reclassification means that maybe they were being brought in and were classified as A, and then it changed. So all that we're asking, is there any evidence of a reclassification by the comptroller? Or is it that the comptroller applied a 5% tariff, which you may argue is a misclassification?
Your
Which
Honors.
is it? You said reclassification.
Yes, Your Honors, and I would like to stand by, and counsel for the claimants would like to stand by that it was a reclassification. Let me be
So we are,
specific as to why.
so that's why
Your
we're asking you, tell us why.
Because, Your Honors, misclassification would have been something done in error. Reclassification is intentional, Your Honors.
Okay.
There was a
That's-
misclassification.
Miss Thomas,
Yes, Your Honors.
I want to urge you
Yes.
to give value to the words coming from the bench. So take your time and absorb.
Yes.
My brother just told you there's classify and reclassify. There was not any classification done by the commissioner and the controller or any other body authority in relation to this case where the comptroller went and reclassified that classification. You understand what my brother was asking?
Yes, Your Honor.
Right, so
I understand.
reclassify as opposed to classify, or as he said, misclassify, is a different thing. And it seems to me if conceptually you do not get clear at the outset that there was, as we seem to think, no reclassification, then conceptually you are at great variance with the bench already. Do you want to go along that path?
Your Honors, I am guided.
Okay,
I
I
am
hope
guided.
so.
I understand and I am guided.
Oh, I'm glad.
Yeah. To go back to the point you were making, because it's an interesting point, you were saying, therefore, that the action of the controller of customs of Trinbago, those actions were actually intentional. I think that's the word you used.
Yes.
So I take it that you were saying that it was clear to the controller that soap noodles came into Trinbago, and yet the noodles were classified as industrial fatty acid pellets in a different category to soap noodles. I take it that you will come to your good faith point on, or would you want to just address us very briefly on how that you see how good faith operates here?
Your Honors, I would like to speak on this when I get to, if with Your Honors' leave, when I get to Article 32. Is that all right?
So you don't think good faith is relevant to 82, Article 82?
Yes, Your Honors, good faith, the principle of good faith is relevant to all the breaches, Your Honors. And this is because counsel for the claimants believe that the actions of the Comptroller of Customs, and by extension, the state of Trinbago, was not done in good faith, Your Honors. And this brings us back to the point of the application to the Secretary General listing the product as soap noodles by the very state of Trinbago. So they were aware that the product was soap noodles, Your Honors. And my co-counsel will discuss this, but there were several letters sent to various bodies of Trinbago.
So it's so that your co-counsel is going to deal with the good faith aspect. Is that what you're saying?
No, Your Honors, I was just
What
mentioning one of the
what we're
points.
trying to you said you're going to start with Article 82,
Yes.
right? And the factual matrix says that the controller of customs of Trinbago classifies the shipment as being, as our president said, industrial fatty acid pellets, not soap noodles, and applies a 5% CET under tariff heading 38.23, right? So that's what we know the comptroller did. Yes. I don't want to get stuck on it. Are you accepting that what the controller did was classified this product as described? The comptroller, that the factual matrix says that the comptroller of customs classifies the shipment as fatty acid pellets and therefore applied a 5% CET. You want to say something about that, right?
Yes, Your Honor.
So what do you want to say about that?
We want to say, Your Honor, that this classification
Yes.
was not done in good faith.
Good. That is what the president was asking you. Right.
Okay, I understand, Your Honor.
Good.
Yes.
Right. So let's go on. So keep going. Mhm.
Sorry. And since you have that clear, and we are all clear on that, do you appreciate that in your written submissions, what you say is that thus Article 82 obliges member states to establish and maintain a common external tariff. Trinbago is responsible for their control of customs, changing the CET. Did he change the CET? Or she change the CET?
Your Honors, I think this can be clarified, first of all, by what Your Honors have guided me in,
Right.
that it was a classification and not a reclassification, first of all. So it is counsel for the claimants mentioned change the CET because counsel for the claimants genuinely believed that the actions of the comptroller of customs was intentional. Your Honors. This is why we
No. Change. Pay attention to the verb.
Your Honors.
These soaps, your thesis is, these noodles should have been classified and the CET applicable should have been 40%.
That is correct, Your Honor.
The controller, did he change the CET on noodles to 5%? Or did the controller say that these noodles are of this description which attract 5%? Did he change?
No, Your Honors.
So that's why what you, I think, want to argue is that we put in parentheses for now, the comptroller intentionally, hence mala fides, misclassified. And that's what you say is a breach. Is that not right? It's a very
Yes,
simple
yes,
argument.
Yes, Your Honor. Yes.
So tell us, try and advance that argument, which I think is at the heart of your Article 82 case, yeah, for leave.
Okay, Your Honor.
If you don't persuade us, you don't get leave, right?
Yes, Your Honor.
Good.
I'm aware. Okay, Your Honor. So the argument is that there was a misclassification. Instead of classifying the soap noodles as soap noodles, they were classified as monocarboxylic fatty acid pellets. And by this misclassification, as was done in the matter of DCP versus the state of Jamaica, the claimants were affected because they were prejudiced of the profit that they would have received had the soap noodles been classified as soap noodles and attracted the 40% tariff. Your Honors, and this is the breach of Article 82.
Yeah, as a court, Ms. Thomas,
Yes.
it if what you allege is true, it doesn't sit well with us that the controller of customs would know that the soap noodles have been imported from Indonesia and yet put a different classification on them. What do you say about that?
Your Honors, I say to this that this is not the first time that the state of Trinbago had ordered these products. It's not in dispute that Trinbago had been ordering these products, and they were previously classified as soap noodles.
Where were they coming from, these products?
They were coming
previously?
from Indonesia. The state of the Trinbago soaps ordered their soap noodles from Indonesia, Your Honors.
We have facts that they had come before from Indonesia? Or is it from somewhere else that they had come from, imported by yourselves?
No, Your Honors, they did import their soaps from third states, and this is the reason for Trinbago soaps sending an application to the Secretary General to get a safeguard certificate, Your Honors. If they were importing from within the community, there would be no need to apply for a safeguard certificate.
But you import from the community.
Yes,
you
Your-
import from Dominica.
That's correct, Your Honors.
And the same soap noodles.
That's correct, Your
I
Honors.
see.
Your Honors, I will now that we have established that 82 has been breached by the misclassification, I will now move on to the breach of Article 83. Now, Article 83 and 84 deal with structure. And, Your Honors, the counsel for the claimants are not ignorant to the fact that Trinbago Soaps is also, like the claimants, an establishment or an entity incorporated under a member state. And so they may feel the need to get some sort of benefit, whether or not they ship their soap noodles from a third state. But Your Honors, we are here to say and to reaffirm the article that there is a structure to having an alteration or a suspension on the CET from third states.
You mean a process?
There's a process, Your Honor. That's it. More eloquently put by you, Your Honor. There's a process. Your Honor, Article 83 specifically states that quoted or the Secretary General acting on behalf of quoted are the bodies authorized to suspend or alter the CET. Your Honors, to this date, there has been no evidence that the misclassification, which resulted in a drop in the CET on the soap noodles, had any authorization from quoted or the Secretary General.
Right, so let me try and see if I understand what you're saying. Your first premise is that what was imported was in fact soap noodles and not fatty acids.
Okay.
That's step one.
Yes, Your Honor.
And therefore,
Hello.
We
will
are
allow-
engaging you, so we will allow you to continue. Thank you. Go
Thank
ahead.
you, Your Honor.
first premise is that what was imported as a question of fact was soup noodles. That the appropriate CET was 40%. The classification as something else was a misclassification and in breach of Article 82. Right? That's step one. That's a breach.
Yes.
So you should get leave. Right. Now you're going on to argue. Just try and express your argument in a very simple syllogism. What is the second part of your argument?
So the second part of our argument
Mhm,
is that
mhm,
if Trinbago soaps
mhm.
needed an alteration or a suspension on the CET, on their soap noodles, Your Honors, it should have been authorized,
They had to comply,
comply
with the
with the
requirements of
Article
Articles
83, which includes that the Secretary General or quoted are the bodies to authorize these changes to the CET.
and on the facts.
And on the facts, Your Honors, there has been no reference to any approval from quoted or the Secretary General. Therefore, Article 83 has been breached.
In fact, their application was refused. Sorry, Judge.
Yes, no.
Yes, which takes us to Article 84's breach, Your Honors. Article 84 speaks about goods of community origin. Let me, like Your Honor has just guided me, let me express the breach of Article 84. Article 84 was breached because in spite of the denial of the application by Trinbago Soaps to the Secretary General for a safeguard certificate, there was still a change in the CET on the soap notice.
Why do you keep talking about a change?
A change in the, sorry, Your Honors, not a change, but there was a misclassification which resulted in a lower CET.
So the question is, that having been established by you, and you are hoping that we have accepted that as established, then why do you need to go on to say what should have taken place when the fact statements are that it did not take place? Why do you need to go on? I'm simply asking a question.
Your Honors, just to reaffirm the breach, we believe that we would have had to repeat it, just to reaffirm the breach of Article 84, or just to emphasize the breach.
If 82 is breached, why do you need to go on to say that the subsequent articles, which are simply, as it were, supplemental or supportive of 82, why do you need to go on to deal with those? I'm just asking.
I'm guided, Your Honor. I'm guided.
No,
Yeah,
but you need to go
Why?
on. But you need to
Yes.
go on. Why do you need to go on? Why do you need to go on? Don't you need to go on? Why?
Why do I
Because
need to
what
go-
are they saying?
They are saying,
They are saying that this was all in good faith.
We are innocent.
right, Your Honors.
We did not mean to breach.
Your Honors, respectfully, this was part of the final argument, and but I
Alright.
understand that it comes up here as well, Your Honors.
But it comes
Yes.
up pivot. You said to us that this is your pivotal argument. But if you are dealing with this issue, which you are, and the defense on the other side to this issue is they acted in good faith and therefore they are not in breach, why would you not deal with it? It's part of a single argument, is it not? You established there's a breach. They are saying it's innocent. It's an innocent mistake. So no liability. Is that not right?
That is what
All
they
right.
are alleging.
So
Your
you're going
Honors,
to
yes.
leave us in suspense until your co-counsel comes to speak about it. We'll wait.
No, Your Honors. I will still, I'm guided by Your Honors.
Now, if you want us to wait, we'll wait. It's all right. We're just raising with you that
Yes.
if it is just part of one issue, maybe in your strategy, you should have dealt with it as a single issue, because that is a logical thing, it seems. All right?
Your Honors.
All right.
Yes. So the breaches of Articles 83 and 84 are breaches because the actions of the defendant were not done in good faith. First of all, they did not have the authorization of the relevant bodies according to Article 83. And second of all, there was a denial of the application for a safeguard certificate by the Secretary General. And there should have been no amendments, or they should have received no benefits, no safeguard benefits.
Ms. Thomas, I wanted to just ask you about Article 84. What does Article 84 seek to do?
Article 84 seeks to offer third state goods in certain circumstances to be classified as community origin. First of all, it does define community origin goods as goods wholly produced, it lists the different conditions, wholly produced within community member states, or where the goods have undergone a substantial transformation. And Article 84 further goes on to speak to the fact that if certain conditions have been met, third state goods can qualify as community origin goods. And they state that.
Sorry.
Yes.
Careful. Could that be really what it is saying? Or they shall be treated, notwithstanding that they are not community origin goods in a
Yes.
certain way?
They
Yes,
be
Your Honor.
deemed, is that the word?
Deemed. That's
Yeah.
the word, Your Honor.
What I wanted to ask you though, how is that relevant here? Do we have any allegation that the goods that were imported by Trinbago Soaps were put into some packaging or put together with perfume or anything? Well, you know the DCPS successors case. Was that the allegation that these goods were then being exported within the community and treated and classified by the controller as goods of community origin? I'm interested to know why you brought in 84.
84. Your Honors, yes, there are facts to that. And the facts are that the soaps, the final product of soap produced by Trinbago Soaps is exported into other community member states. Now, the soap noodles, as we would have seen in the DCP case, they do not undergo a substantial transformation from soap noodles to soap. It can almost be under the same category, if I understand clearly from DCP case. Now, the packaged soaps from Trinbago Soaps are labeled as being of community origin. Therefore, they would attract benefits on their exportation as community origin goods, which they are not. Because under the definition, Your Honors, of community origin goods, there should have been a substantial change in the product for it to be classified as such. This is not the case with the Trinbago soaps, and therefore the labeling should have been in accordance with what they are, third state soaps.
I understand what you're
Yes, Your
saying,
Honors.
but I may have missed it, but I did not see in the brief anywhere that indicated that the controller was given a certificate that these goods were goods of community origin when the goods were exported to Jamaica. Could you assist me there on the facts?
Yes, I can, Your Honors. No, there's nothing in the facts that states that a certificate was being given. So this is not what we are alleging. What we are trying to prevent is an extension of the actions of Trinbago soaps in their packaging of their soaps and labeling it as being of community origin, which it is not.
So are you accepting therefore that on the factual matrix, there's no evidence to support a breach of Article 84? As yet? Is that what you're accepting?
No, Your Honors, this is not
So
what we
there
are
has
accepting.
been a breach of Article 84?
Yes, Your Honors, because Trinbago soaps are packaging their soaps and labeling them as made in as products of Trinbago, which they are not.
They are not. Okay, fair enough. Yeah? Mhm.
Yeah. Well, ma'am, we've taken up a lot of your time and we've also gone over time.
Yes, Your Honor.
So we could give you 2 minutes to wrap up.
Thank you very much for that 2 minutes, Your Honors.
Okay,
So
do it.
I will now move on to the breach of Article 82 very briefly.
32.
Oh,
32, I'm so sorry, Your Honors.
Okay.
Yes. I'll move on to the breach of Article 32, Your Honors. Article 32 speaks of the right of establishment of community enterprises, enterprises under the community, Your Honors. And right of establishment goes beyond just the creation of the enterprise, but the management, Your Honors. In management, there is financial management. Your Honors, the breach of Article 82 would have resulted in TT distributors, the claimants, suffering financially. This is already a frustration of the right of establishment of TT distributors, Your Honors. Their financial status has been frustrated.
And if you frustrate somebody's financial status, you are interfering with their right of establishment.
That is, yes, Your Honors.
What is involved in the right of establishment?
The Article 32 specifically explains that the right of establishment includes the creation and management of the enterprise. This is what it states.
It speaks of the right to engage and to create and manage. So it's the right to engage in any non-wage earning activities
Yes, Your Honor.
and the right to create and manage economic enterprises.
Yes, Your Honor, their right to create has not been frustrated, but their right to manage.
Why? Why is it?
Your Honors, because they would have preempted certain benefits, certain profits.
But the question of benefits, the question of profitability, the question of competition and so on, how do those get into prohibition of new restrictions on the right of establishment?
What counsel for the claimants are stating is that indirectly, the breach of Article 82 resulted in a restriction of their right, of TT distributors' right to manage the enterprise. That's what we are
With the
submitting.
greatest of respect, I want to tell you that just off the top, and I promise I will consider it more fully hereafter. But right off the top, I can't see that. What it has done is it has left TT distributors in a situation where they are managing a now threatened business, which has now been put at risk of its survival because of the actions of the state.
Yes, Your
Yeah.
Honors, and further, the third
Sorry,
state-
sorry.
I'm
No.
sorry, Your Honor.
No, it's not the question of further. Deal with that.
Yes,
If that is what it has done,
yes.
then I'm suggesting to you, it has not interfered with the right to manage.
Okay,
It
Your Honor.
has created a situation where you are left with managing a now imperiled business. Yeah?
Yes, Your Honor.
Okay.
Your Honors.
Am I correct or?
Yes, Your Honor,
Well,
you're very correct.
thank you.
That's why we reference the
Yes.
TCL and Guyana
Thank you.
case, where it states that the CET was supposed to offer a competitive advantage and a competitive economic advantage. So there's an unfair advantage that the third state goods are now having on the goods from TT distributors, which has affected their financial status.
Yes, as you close off there, because you've really gone over time, but you have no opponents, so we have to be your opponent. I'm intrigued by what you say about Article 32. You seem to have read the TCL 2009-1 case well, and the court makes some important points about that. Can an entity like your client, TT Distributors, can they argue their right of establishment under Article 32 has been reached by their own state?
Yes, Your Honor. And if I understand the question correctly, I think it refers again to Article 220. It brings us back to 222.
No, 222 is what locus
Locus standi,
to
right.
get in the door.
Right.
But if you're in the door
We in the door.
and you now have to look at Article 32, what do you say? Do you have locus under Article 32? What is required? Can you have a right of establishment against your own state?
Yes, Your Honor.
The state wherein you are established.
Yes, Your Honor, because the actions of the state can affect the businesses of the state. That's what we believe. The actions of the state, by allowing the comptroller, by not stopping the actions of the comptroller, has affected the.
Yeah, but hold on.
establishment.
Has affected. That is not what the treaty speaks about, affecting under Article 32. Create and manage, yeah?
Prejudice their right to create and manage the enterprise.
Okay.
But
All right.
but you see, read 32(1). You have the article in front of you?
Yes, I do, Your Honor.
All right. So it says that a member state shall not introduce restrictions in relation to the right of establishment in their territory, right? So if the Dominica company, yes,
Yes, Your Honor.
had experienced restrictions in establishing their business in Trinbago, that could be would you agree that is a clear potential breach of Article 32? Because the Dominica company is trying to establish a business in another member state. So assuming the Dominica country is entitled to the benefit of the right of establishment, then another member state ought not put obstructions or restrictions to that right of establishment of a business from one member state in another member state. So far, so good?
Yes, Your Honor.
All right, good. But that benefit accrues to the Dominica company, i.e., to be able to establish its business in another territory. You with me?
I have to ask you to repeat that last point, Your Honor.
The right of establishment is a right of an entity in one member state, Dominica in this case, to establish its business in another member state, which it purported to do by incorporating a company, no hindrance, TT Distributors, setting up a business, and packaging 3 soap products in Trinbago. There is no evidence that that was restricted or compromised, i.e., the establishment of TT Distributors in Trinidad and the setup of the business. Your complaint is that by allowing a competitor in Trinidad to import soap noodles without applying the 40% CAT, the profitability of the business that has been established in Trinbago is under threat.
Yes, Your Honor.
So that's why I assume you say that it is an indirect interference.
Yes, Your Honor. As well, it's indirectly it's an indirect restriction of the right of establishment, not only of TT Distributors, Your Honors, but by extension, Dominica Soaps.
This is the first time you're saying that.
Supply TT Distributors.
That's the first
Your
time you've said that.
Has Dominica Soaps joined this application?
No, they have not, Your Honors, and this is because the direct impact, the more direct impact is with TT Distributors, and therefore we have decided to bring the action for TT Distributors only.
Thank you. As we close, it may be that you would want to take instructions from Dominica Soaps
Yes, Your
and
Honors.
make an amended application. But
Or-
we can't
or-
hear you further.
Or maybe what you need is to tell Dominica Soaps, you need to bring an action quick.
Yes, I think that will be our next step. You might hear
Okay,
from us.
great.
And I'm sure Mr. and Mrs. Hassans are listening. So
Yes,
thank
they are.
you.
They are. Thank you. If there are no further questions from Your Honors,
No.
I will.
Justice Jamana has a lot more to ask, but that would not be right. Thank you
right.
very much, Ms. Thomas. We
I will now
appreciate
pass the
all
baton
that
on
you've
to
done.
my co-counsel, Mr.
Yes.
DVD Ramdas.
I will
Thank you
save
very
my
much.
questions for your co-counsel.
May it please the court, my name is Devidi Ramdas and I appear on behalf of the claimant in this matter, TT Distributors.
Okay.
Your Honors, in addition,
Raise the microphone. There we go.
is that better? Your,
I think it's better.
Your Honors, in addition to the articles that my colleague mentioned, we submit that the state of Trinbago has also breached Article 91 of the revised Shagaramas. With Your Honor's leave, I would like to proceed on our substantive points on this issue.
Yes, please proceed.
Your Honors, we seek to demonstrate firstly that under Article 91(1), Trinbago has imposed quantitative restrictions which are prohibited under the treaty to imports from TT distributors. Secondly, we seek to demonstrate that Trinbago has failed to take necessary measures to stop the evasion of restrictions placed on community goods, placed on non-community goods, contrary to Article 91(3) of the revised Treaty of Shagaramas. And finally, we seek to assure Your Honors that the claimant is entitled to a variety of reliefs stemming from the state of Trinbago's breaches of several articles of the treaty that my co-counsel has adduced, as well as Article 91. As a starting point, we submit that Article 91 prohibits member states from imposing any quantitative restrictions on goods within the community. We submit that Article 91...
Sorry. That's a lovely elision. You elided the word, the importation.
That was an omission, Your Honor.
Well, it was a very convenient omission for you, Madam Counsel,
Your Honor,
because you are faced with the prospect that there is not any importation by TT distributors of anything in this instance which is under restriction?
No, Your Honors, we submit that TT Distributors' main business is the importation of soaps from Dominica. And
Noodles,
yes,
soap noodles.
yes, Your
And so what is the restriction on that?
The restriction on that stems from the articles that my colleague had mentioned, that by the comptroller taking unilateral action to reduce the CET on Trinbago soaps, imported soap noodles from Indonesia, the effect of this has amounted to a measure with equivalent effect as a quantitative restriction on our claimants' community goods.
No. That can't fly. What is the restriction on the importation by TT Distributors Limited of its pellets from, or its noodles from Dominica? What is the restriction on it? I understand that your client's case is that it makes the product non-competitive. Yeah, it makes TT Distributors' product non-competitive because here it is our competitor being given the opportunity of bringing in third-party products at a vastly misclassified rate. Yeah, but what is the restriction on TT Distributors importing from Dominica their noodles?
Your Honors, under Article 91(4), it provides that quantitative restrictions are not merely quotas or licenses.
I am not dealing with quotas at all. I'm asking what is the fact? What is the fact of restriction on the importation of this material from Dominica?
The restrictions are both the comptroller's actions and the false and misleading campaign executed by the Trinbago
The
private sector.
comptroller's actions are directed at allowing Indonesia soap to come in at the wrong classification, the wrong tariff, yeah?
The comptroller's actions are not just restricted to letting Indonesian soaps into the market at a higher level of competitivity, but the comptroller's actions have a ripple effect, Your Honor.
Yes, you're talking about ripple effect. I am not dealing with ripple effect. I'm asking about the restriction on the importation into Trinbago of the Dominican soap noodles.
The restriction is a restriction of quantity because TT Distributors, a community company importing community soaps, is not being given the competitive advantage to which they are entitled. This frustrates their movement of
So the denial of the competitive advantage is the denial of the benefit of Article 82. So how do you get under 91?
Because 91 speaks about quantitative restrictions. And when we restrict a company's competitiveness in the market, by extension, the amount, the quantity of products that they can import will necessarily be restricted as well.
Ms. Ramdas, I think we get your point and how you intend to argue it. So it appears to me that you're really arguing not any quota, not any issue of import license, but you're arguing a measure with equivalent effect.
Yes, sir.
But I am interested to know, did you find any cases that would assist? I know that the CCJ has not dealt, but I imagine there are many cases in the ECJ, for example, that would have assisted you. But we've not seen anything at all in your written submissions, to our dismay.
You're correct, Your Honor. Unfortunately, we did not submit any cases from
But you
the
found them? Have you found them? Are you aware of the Apple and Pear development case of Commission in France? You're aware of those cases?
where we have looked at a number of ECJ cases, including a
I was
case-
waiting for your response to our brother to say, to support all this ripple effect and indirect effect, to say that by analogy, in the same way that in apple and pear, those kinds of private entity undermining of the sale of products that satisfy the our Article 91 breach, that by analogy you would apply to the CET. But you haven't said that, and there are cases that allow you to say that, so that the president raises, I think, to our disappointment, that you've advanced an argument, it is created. I think there is precedential support if you argue by analogy. Because at some point, are you also going to come to talk to us about what's the name of the private entity in Trinidad, in Trinbago, that is carrying on the campaign? TPSO?
Yes.
Well,
Your
all
Honor.
right. Are you going to argue that TPSO, the actions of TPSO are attributable to the Trinbago state? Are you going to argue that?
We are going to argue that the actions of the TPSO can be regulated by the state of
And
Trinbago.
therefore, the state of Trinbago is, in international law, in breach of Article 91.
Yes.
And you're going to rely on 91.4.
We're relying on 91.3, the power
Right, correct.
under Article 91.3
So,
to stop the EP.
isn't the CET argument, it is creative, I like it. But it is an argument by analogy.
Yes.
What are the cases that support the argument against TPSO? What are the cases? You haven't written them down. What are the cases?
We were going to adduce Rudisa beverages, even though it did not speak about Article 91 specifically. It did deal with the breaches of Articles 87.
But what are the European cases on the, is it Article 30? What is the equivalent article? Is it 30?
I think it was 30 or 35 of the European treaty.
Have you read Dr. Berry's book on community law?
No, I have not.
You have not. He writes on this specifically, and he has all the cases there. I didn't do any fancy research. I just read the chapter in his book. But you're coming to advance a case before us, and you need to prepare and find support for your arguments.
I am guided, Your Honor.
That's what we expect. You shouldn't leave me to do the research or the president to do the research. You have to help us. Anyway, let's move along.
Yeah. So we are submitting that the state of Trinbago, by allowing this campaign to take place, by refusing to regulate it, despite several pieces of legislation in Trinbago providing multiple opportunities for the state of Trinbago to take action against this false and misleading campaign, by choosing not to address the TPSO's false and misleading advertising, Trinbago has in effect endorsed the undermining of the RTC contrary to Article 91.3. We are also adducing that Article 91.3 should be considered in light of the state of Trinbago's general obligation under Article 9, which provides that the state of Trinbago should take all appropriate measures, whether general or particular, to ensure that its treaty obligations are fulfilled. So our argument is that by failing to take those measures, Trinbago has allowed our client, TT Distributors, to have their benefits, their rights to freedom of movement of goods and imports, to be frustrated. And that is how they have breached Article 91.
I think it's a very well constructed argument, right? I'll encourage you, as I said, I'll just share it with you for your own benefit. In the apple and pear case, the ECJ distinguished between campaigns that discourage the product of goods from another state, which may fall into this factual matrix, which disparaged against the products. Well, you know that they say only natural. That's not true. Your products are natural, correct?
Yes, Your Honor.
Right? And spoke about safety. And by implication, your products are unsafe. So that's kind of putting down your products. Or discriminated on the grounds of origin. Here they are talking about made in Trinidad is better and safe, but guess what? What is the point of origin of their soap noodles? Not even the Caribbean, correct?
Yes.
So on the three sort of criteria that this case sets out, I assume that you may have an arguable position. So you want leave from us, right?
Yes, Your Honor, we are
Right.
taking leave.
Yeah.
Yes, one thing I wanted to ask you, did you consider at all, before you file your application for special leave, that the measure by the campaign, by TPSO, really amounted to some sort of an unfair advertisement or campaign, and that you ought to go to a national court to get the relief instead of coming here?
Yes, Your Honors, we considered this, but
You didn't tell us so, did you? Did I miss it?
we are seeking to expand
You
now.
kept too many things to yourself, ma'am.
Yes, I'm guided, my lady, Your Honor. But we have considered that due to the rules of the original jurisdiction, that any matter that was brought before the municipal courts would ultimately have to be referred to this court anyway. So to conserve our clients' resources, we decided to bring the matter before the CCJ initially.
Okay, so you saw this was a case, if you had filed it in the High Court for some sort of relief, that the judge would have had, or you would have asked the judge to refer it to the CCJ. Is that what you're saying?
Yes, Your Honors. And in addition to all the other articles that my colleague had mentioned, we are submitting that these articles are fit for interpretation only before this court. So that is why we brought it here.
Thank you.
Good, yeah.
Okay. So Justice Jamada, my brother, was asking you about the relief you saw.
Yeah, well,
From
yes,
us?
and
Yeah.
you are in a practical court, and you've come for leave, yes?
Yes, Your Honor.
But you're alone, there's nobody opposing you. So what do you make of that? I mean, yes, you've given us all these arguments, but there's a practical thing here going on. You've served the other side with your application?
Yes, we have.
Yes, you have. Of course you have. And they haven't turned up.
Yeah.
So what do you say to us?
We say that the court is entitled to grant the reliefs that we seek in their absence. And firstly,
But
we
you
are
don't
seek-
take advantage of that, do you?
We are not taking advantage if there is no defense. So we,
You're entitled to take every advantage that is available, right? As a good advocate.
yes,
But you also have some merits in your application.
yes.
All
we-
right.
We submit that we,
Yeah.
And a duty to the court.
yes.
So what are you seeking as you close? I think you're out of time, but we let you close with your relief. What do you seek?
Firstly, we seek a declaration that the state of Trinbago has breached several articles of the RTC, namely 32, 82, 83, 84, and 91.
So you don't seek leave again?
Yes, Your Honor, we seek
And,
leave.
and if you get leave, what would you do under the rules, the CCJ, OJ rules? What do you have to do?
We have to make out an arguable case.
Well, let's say you have and we grant leave. What do you do next?
We are now seeking the reliefs that,
You will bring the application for the relief that you want.
yes,
So you'll
Yeah.
file the originating application,
application.
and then you will seek the declaration.
yes, yes,
All you want
So-
is just to get over the bar now. That's all.
yes.
So I think what my colleagues are indicating to you is that do not argue the case now, and do not proceed on the premise that this is the arguing of the case. As my colleagues have indicated, all you are entitled to at this juncture, if you are entitled to what you're seeking, is the ability to bring a case. You don't have a case yet.
I I'm guided, Your Honor.
I'm glad you are. Okay.
And if we were to
Nothing else.
if we were to receive leave, the application for relief that we would make would include a request that this court grants a declaration for that the state of Trinbago has breached Articles 32, 82, 83, 84, and 91 of the revised Treaty of Chaguaramas. And this would signal not just to the respondent, but to the community at large that no attempts to get around the RTC, regardless of how innovative they might be, would be allowed by this court.
Okay.
Secondly, we seek an injunction that
You will see.
we will seek an injunction.
I think we will see what you are seeking here, unless there's anything that you have not written.
I am guided, my lady. Unless there is anything further, this is the extent of our submissions.
Nothing else.
Thank you very much, Ms. Ramdas.
Yeah.
Yes. I believe that that is it, Ms. Thomas. Thank you very much. to
Yes, Your
both
Honor.
of you. And we shall rise and return at 1 o'clock for our final session. Thank you very much.